Hello. I'm Bing Chen, partner of SPTL. With me is my dear colleague, today's presenter, Ms. Wenyu Qian. Wenyu is our senior patent attorney and litigator, who has been practicing IP for over 8 years. She has wealthy experience in prosecution, consultation, and post-grant procedures, like invalidation and litigation, with focuses on technologies in biotech, medicine, and biopharmaceuticals. Today, she will guide us to have a close look at the drug patent linkage in China, which has been long discussed, awaited, and now finally laid down by the new amendments to Chinese patent law. She will bring us most recent updates on implementation of the system and share with her insightful thoughts and tactic recommendations. The presentation will last for around 40 minutes. Questions are welcome anytime during the presentation. You may type in your questions and send them to us. All participants are muted. We will have a session for Q&A after presentation. Get back to you with the answers and to answer questions in live. Now I'll hand over to Wenyu. Hi, Wenyu, over to you.
Thank you. Good morning, good afternoon, good evening. This is Wenyu Qian. Thank you for coming to this webinar. Today, I'm going to talk something about China's drug patent linkage system that has been newly established this year. This presentation mainly includes relevant legislative history, framework and key elements, practical considerations and strategies, and conclusion. First, I will begin with the relevant legislative history of the system. As you may know, in China, the administrative protection of drug patents and the management of drug marketing approval are in charge of CNIPA and MNPA, respectively. They were completely independent in the management and approval. So, patent infringement disputes were always left unsolved until generic drugs are marketed. Both the patent holders and the generic drug companies need to spend a lot of costs for the belated resolution. To solve this problem, China has gradually tried to explore for corresponding resolution mechanism. In September 2020, MNPA and CNIPA jointly published the draft of the 12 implementation measures for the early resolution mechanism of drug patent disputes as an effort to set up a drug patent linkage system in China. In October the same year, the latest amendment of the patent law was passed, in which Article 76 provided the legal basis for the judicial and administrative ruling of the system. In the same month, the Supreme People's Court published a corresponding judicial interpretation, also a draft for public comment, which was intended to improve the litigation procedures in relation to drug marketing approval and administrative ruling. Then, in this February, CNIPA introduced a corresponding administrative ruling mechanism, another draft for public comment, with the effort to provide a more operable system to support the practice of the new patent law. These drafts of regulations, which were published one after another, attracted great attention from the industry. After months of discussions and balancing between all parties, then, on July 5th, MNPA, CNIPA, and Supreme People's Court issued a series of regulations, which all took effect immediately. So far, China's drug patent linkage system has officially launched. Now, I will move on to show you the framework and the key elements of this system and how it will work. First, as a basis of the new framework, NMPA has set up an online platform called China Patent Information Registration Platform for Marketed Drugs, which is maintained and overseen by NMPA's Center for Drug Evaluation, also known as CDE. This is a screenshot of the platform's homepage. First, you can see a search box here. You can query the published patent and drug information by drug name, patent number, or the name of the pharmaceutical company. Below, there are 3 function module entrances: patent registration, patent information publicity, and patent certification. You can click on the module to open the corresponding module page. The patent registration module is for marketing authorization holders, MAHs, to register patent information on drugs registered and marketed in China. The holders can register the information on the platform within 30 days after receiving the marketing approval. If any related information is changed, it should be updated accordingly by the registrant within 30 days after the change takes effect. Notably, patent registration is not mandatory, but unregistered patents will not be eligible for the patent linkage system. Also, another thing to note is that the category of the patents that can be registered are provided. For chemical drugs, patents that can be registered are those for active pharmaceutical ingredients or the API compound, patents for API containing pharmaceutical compositions, and patents for medical uses. For biological products are patents for API sequence structures and medical uses. For traditional Chinese medicines are composition patents, extract patents, and medical use patents. It should be noted that the categories do not include patents on intermediates, metabolites, new crystals, preparation methods, and testing methods. The MAHs are responsible for the authenticity, accuracy, and completeness of the provided information. For any received objection to the information registered, it should be verified and recorded by the MAH in a timely manner. So, that's the patent registration module. So, in the middle is the module of patent information publicity, which is set for the public, especially for generic drug companies, to search for registered patents of a marketed drug. In this module, you can browse the published patent information by categories like chemical drugs, biological products, and traditional Chinese medicines. Or you can also search the database by the target, by drug name, registration number or approval number, specification, or the dosage form of a drug. Now we come to the third module, patent certification. This is used for publishing the new drug application and patent statement information by the generics. When a generic drug developer submits a market application, it should make a statement for each relevant patent of the reference drugs. Specifically, the statement is classified into 4 categories. Category 1. There were no relevant patents registered on the platform. Category 2. The registered patent has expired or has been declared invalid, or the generic applicant has patent license from the patentee. Category 3. There is a registered patent, and the generic applicant will not market the drug until expiration of the patent. And Category 4. There is a registered patent on the platform, but it should be invalid or it does not cover the generic. So, if a Category 4 statement is made that the generic does not fall within the scope of the relevant patent, together with the statement, the generic applicant should also provide a chart comparing the technical solution of the generic drug and the relevant claims of the registered patents, and also relevant technical data as supporting materials. Within 10 working days, the CDE will publish the application and statement on the platform. So, that's the platform, a registration and disclosure system set up by MMPA. As the platform publishes patent information of both chemical drugs and biological products, in a sense, it can be compared to FDA's Orange Book and Purple Book. Now, let's take a look at the marketing approval process of generic chemical drugs. For Category 1 and Category 2 statements, the CDE will make the market approval decisions based on the conclusion of the technical review. For Category 3 statement, the generic applications that pass the technical review can also be approved immediately, but it cannot launch the market until the expiration of the patent, and also of the market exclusivity period, which I will talk about later. For applications with a Category 4 statement, if no opposition is filed by the patentee or an interested party within 45 days, which is calculated from the date application is published, the MMPA can directly make a decision for marketing approval. And also, in this scenario, the generic applicant could move for a lawsuit or an administrative ruling to confirm its product not falling within the scope of the relevant patent. If the patentee or interested party holds an objection to the statement, within the 45-day period, it should file a lawsuit to the court or request administrative ruling by CNIPA, and then notify the CDE within 15 working days after the case is instituted, which will trigger a stay period up to 9 months at CDE. During the stay period, the technical review will not stop, and the stay period will be ended if the two parties come into a settlement, or if the patent is invalidated, or if the generic drug is confirmed to fall within the scope of the patent, or if an effective ruling by the court or a decision by CNIPA is not available within the 9-month stay period. If the generic drug is confirmed to fall within the scope of the patent, the generic application will not proceed to a final approval by CDE until approaching the patent expiration date, that is, a stay of the market authorization. It's worth mentioning that the first generic chemical drug to successfully challenge innovator drug patent can enjoy a 12-month market exclusivity period. So that's the approval process that the generic chemical drug may go through. For this process, there were some key points to note. First, as you may have noted, a judicial and administrative dual-track system has been set for early dispute resolution. For the administrative linkage system, CNIPA has set up a separate administrative adjudication board for specially handling the early settlement of drug patent disputes. Before applying for administrative ruling, make sure that people's courts have never accepted a patent concerning the same drug. The relevant claim of the patent remains valid, and the request form should be filed against one technical solution concerning one claim only. Otherwise, the request will be rejected. Well, for the judicial approach, the Supreme People's Court has designated Beijing Intellectual Property Court as the court of the first instance. The corresponding judicial interpretation also provides that the People's Court will not suspend the litigation on the grounds that CNIPA has accepted the request for administrative adjudication, and in general, will not suspend the litigation on the ground that the invalidation request of the relevant patent is accepted by CNIPA after institution of the lawsuit. Also, the court applies the res judicata doctrine, which means that when determining whether the same drug falls within or outside the scope of the same patent, in general, the court follows a previous effective judgment, unless evidence proves the opposite. As I've just mentioned, the patentee or interested party would trigger a 9-month stay, which starts from the date of the acceptance of the case by the court or CNIPA. During the stay period, CDE will not stop the technical review, but it will suspend the approvals until the ruling results are issued. If the drug is confirmed to be within the scope of the relevant patent, the administrative approval process will be held off until expiration of the patent period. It should be noted that the stay period for the same generic drug is set only once. The next thing important is exclusivity of the first generic drug. To incentivize generics to seek early drug entry, China provides a market exclusivity period of up to 1 year for a generic drug company that is the first to challenge and succeed in invalidating the innovator's patent and the first to put the drug onto market. During the exclusivity, the CDE may review, but will not approve other generic applications. This exclusivity period will not exceed the patent term that has been challenged. The next point is the different handling of biosimilars and TCMs of the same name and formula. Unlike generic chemical drugs, there is no stay period or market exclusivity period for biosimilars and TCMs of the same name and formula. The CDE may approve directly based on the conclusions of the technical review. If a decision is made in favor of the patent owner before the marketing approval is made, the CDE will not approve the application until the relevant patent expires. So, it seems that the patent linkage system for biosimilars and TCMs of the same name and formula is currently incomplete, and we expect this part to mature over time. We made a comparison of key points between China and the United States for the approval process of generic chemical drugs. First, as I've just mentioned, China has set a dual-track ruling system. CNIPA and the court both are the options for the ruling. While in the United States, a patent owner has to file an infringement suit in federal court against the general applicant. Also, different from the artificial infringement doctrine in the United States, the Chinese patent law does not take the marketing application as an act of infringement. It provides that if a drug patent dispute arises during the generic application, the involved party may petition for judgment on whether the drug of application falls within the scope of the relevant patent. The time limit for the patent owner to sue or petition is 55 days in both China and the United States. The waiting period of up to 9 months in China is much shorter than the 30-month stay period in the United States. The exclusivity period of up to 12 months granted to the first successful generic challenger in China is much longer than the 180 days of exclusivity period provided in the United States. As you can see, in some key points, there are differences between China's system and that of the United States. China has built this system based on its national conditions and practice. So for this new system, currently, there are some considerations of practice and also strategies for innovators and generics. For innovators, I think there are some points worth noting. First, to register or not. As I just mentioned, as the basis of the system, a platform for patent registration and information disclosure has been set up. If you are an MAH, you can list patent information on the platform, but a listing is not mandatory. So you can decide whether to do the listing or not based on your commercial planning and strategies. However, it should be noted that unlisted patents will not be enrolled in the patent linkage system, which means that you cannot resort to linkage to solve disputes early or to prevent or to delay the marketing of generic drugs. So to register or not, it's worth thinking about. The next thing is what patents to register. As you can see, the market exclusivity of up to 1 year is quite incentive for generic to challenge. So a recommendation here might be that the innovators be mindful in selecting certain patents to be listed on the platform, while keeping others away from Category 4 challenges. Another suggestion is to be prepared in advance. I would suggest innovators to keep a close eye on generic drug applications. Be prepared in advance to defend your listed patents and to move quickly when necessary. Of course, it will be critical to have on-the-ground advice from Chinese Patent Council about legal and practical strategies in any given situation. So if you need any consultation or advice, we'll be pleased to help. We also have some suggestions for generics. First, to find and target. If you intend to enter the market early, you can log in the targets as soon as possible through, for example, due diligence to analyze the stability of the listed related patents, and when there is sufficient evidence, raise patent challenges in a timely manner to move obstacles in the way. The next thing is validity challenge. If you want to accelerate the market approval process, you may commence invalidation proceedings against certain registered patents. Generally, an invalidation challenge moves quickly and can be concluded in about 5 to 6 months. And the first successful generic challenger can enjoy 12 months market exclusivity, which is surely a huge advantage. Well, another suggestion is to take action proactively. So for category 4 statement, if the MAH or the patentee does not take an action within a 45-day period, I would suggest the generic applicant to move to the court for ruling that the generic drug does not fall within the scope of the patent. Since the court applies the doctrine of res judicata, this can prevent the patentee's attack by filing an infringement lawsuit after the generic drug is marketed. So, as the new system has just kicked off, we are expecting more details and clarifications, as well as case laws. Still, attention is invited from both innovator and generic drug companies, for the new system brings both challenges and opportunities. As seen, so I just introduced the drug patent linkage system set out by the current rules, which is surely a milestone in the patent regulatory framework in China. As you may have noticed, besides this system, other systems are also running or developing in China. For example, we have already introduced border exception, and we have a proposal of data exclusivity under consideration. And the amendment patent law has also introduced PDE as a compensation for new drugs. So it is believed that the whole framework will be refined and improved gradually in practice. If you would like further details or updates, or if you need advice or support, feel free to contact us and we'll be glad to be helpful. That's my presentation today. Thank you for your attention.
Thank you, Wenyu. Thank you for your sharing. It's quite informative and very practical. Now it's Q&A session. Please type in your questions and send them to us. We will be glad to answer any of your questions. Good. We have a question from Mr. Colin Hanks. Thank you, Mr. Hanks. The question is, if the MAH is not the patentee, can he or she list the patent on the platform? Wenyu, please.
Thank you. Well, thank you for asking. So your question is, well, if the MAH is not the patentee, Okay. According to the regulations issued this July, it is the MAH to list patent information on the platform. But as you asked, if the MAH is not the patentee, and well, I think an authorization from the patentee is needed. Yes, thank you.
Okay, thank you, Wenyu. Here is another question. It's from Ms. Jennifer Mayer. The question is, to kick off the stay in NMPA, how to choose between judicial or administrative approach?
Okay, judicial and administrative approach. Well, thank you for your question. So, you mean innovators? Well, that's a good question. So, well, in my opinion, the administrative approach will be more efficient because CNIPA will set a ruling board specialized in handling such disputes. Well, and also an administrative ruling will be enough for the CDE to make a decision, you know. But for the administrative approach, one thing to note is that the patent office will not accept the case if there is a parallel lawsuit. Okay, so for the judicial approach, well, it can be time-consuming. Well, in view of the backlog of cases at the court, and also, well, you need to wait for the judicial judgment to take effect. So, and if the opponent appeals, it can be even longer. Okay, this is the judicial approach. But you know, there are always pros and cons. So the advantages can be that an effective judgment from the court is more final than the administrative decision, and well, it will not be affected by a parallel administrative proceeding. So, well, if you ask me, so my suggestion is that you may first file administrative ruling request with the office, and after the case is accepted by the office, then file a lawsuit before the court, or if desired. Okay, thank you.
Okay, let's see if there are any further questions. Well, we are gonna close today's webinar here. Thank you very much for your interest and participation. With these webinars, we as SPTL is devoted to bring you the latest news, events, and trends of IP practice in China. Our next webinar will be November 25th. Let's have a glance at how internet evidence is used in patent practice in China. Hope to see you next time. Bye-bye.
Thank you.